Good afternoon. I'm Matthew Spalding, Associate Vice President Dean for Hillsdale College here in Washington, D.C. Welcome. In particular, welcome to the Kirby Center for Constitutional Studies and Citizenship. Great to have you here for our monthly lecture series. Religious liberty was probably the most important thing established in the founding of this country. Before that, as Washington famously wrote in a letter to a congregation of Jews, the first letter, as far as I know, written by the President of a democratic republic to a congregation of Jews. He pointed out that we no longer rule ourselves by toleration, but by liberty, religious liberty. The establishment of religious liberty was the most important thing established in this country. At a time when we are increasingly challenged about our religious faith in the public square, and institutions such as Hillsdale College are challenged in how they understand that religious faith, and institutions that are themselves religious, both formally and informally, are challenged about that faith. It behooves us to think more clearly about the meaning, the real meaning of religious liberty, and more importantly, the understanding of faith, especially as we now enter a period of court cases which will look at that question. We're going to hear today from a very, very fine scholar and a dear friend of mine personally, but also of Hillsdale College. He's going to be introduced by one of our students. I would mention, I think we mentioned again as well, but one of the reasons why the professor is here today is because he has recently, in addition to his many things, focused on founding and building up the James Wilson Institute. He is a foremost thinker in this country about the relationship between natural right, natural law, and American constitutionalism, and now has an institution in which he's going to do more work in precisely that area. And I bring it to your attention. And I'm very, very pleased that he is here with us today. Introducing him is one of our students, Corbin Killinger. He is currently interning with Valenti & Associates, a lobbying firm here in Washington, D.C. He is a political science major, minoring in business administration. He's from Oregon. He's a junior, but graduating in December of 2014. He's a member of Tau Delta fraternity, and he's the team manager for Hillsdale's women's swim team. Corbin.
Thank you, Dr. Spalding. Before introducing our speaker today, I'd like to bring to your attention a special opportunity for young lawyers, law students, and clerks. The James Wilson Institute is partnering with the Alliance Defending Freedom to offer a week-long fellowship at ADF's Legal Academy this July in Naples, Florida, for anyone who's interested. Philosophers of law will lead sessions regarding natural rights, the moral ground of law, and jurisprudence, with the intent of inspiring the next generation with the principles of law that founded the American regime. And for anyone who's still interested in that, you may contact James Wilson Institute Assistant Director Garrett Snedeker. This afternoon, we have the pleasure of hearing from the founder of the James Wilson Institute, Dr. Hadley Arkes. Fittingly titled Recasting the Case for Religious Freedom, Dr. Arkes will be presenting his case for why the principles of liberty and the rules of law are a compelling defense for religious freedom. Dr. Arkes has been a member of the Amherst College faculty since 1966, where in addition to teaching political science, he founded the Committee for the American Founding, a group of alumni and students seeking to preserve the doctrines of natural rights taught by the American founders. Dr. Arkes has authored a collection of works including The Philosopher in the City, Beyond the Constitution, and Natural Rights and the Right to Choose. Apart from his accomplishments in these outlets, Dr. Arkes has become known to a wide audience through his writings in the Wall Street Journal, the Washington Post, and the Weekly Standard. He brings us today a thorough experience with topics involving constitutional jurisprudence, natural law, and challenges to moral relativism. Please join me in welcoming Dr. Hadley Arkes.
Thanks, Corbin, for that nice introduction. When somebody says something like that, I usually say, I just came in to read the meter and they asked me to offer a few words. I see so many friends here, so many distinguished people. We could turn this into the old Ed Sullivan show, and I could start we have a great architect in Milt Grenfell, we have Howard Sedgwick, we could do Tom Spence here. I was just reminded that I gave the launching lecture in this hall a couple of years ago. Now I'm pleased to be part of a series to mark the advent of Matt Spaulding to the Kirby Center in Hillsdale, which marks a new phase, I'm happy to say, for Hillsdale in expanding the offerings in undergraduate education, in projects on the Hill, and really making clear, I think, the new standing of Hillsdale in the firmament of this country, while the old Ivy League colleges, I think, are imploding. I want to thank Matt also for rescheduling this talk after the snow of last. So this talk is a week old, and so are the sandwiches. No, the sandwiches are fresh, and so is the talk. Years ago, there was a famous story about the Yiddish theater in New York, the Yiddish version of Macbeth. The sign said, Shakespeare's Macbeth, übersetzt und verbessert, translated and improved. So I'm offering this talk now, verbessert und sharpened, improved and sharpened a bit. And I should thank here also, this talk, an earlier version, was invited by our friends at the Wheatley Center at Brigham Young. And the finished product will be part of a publication, pieces with Robbie George, Akil Lamar, and others, edited by our friend Dan Robinson. To the discomfort of my wife, I've preserved an interest over the years in Henry James. And Henry James at times would fold these long, winding sentences where you really couldn't tell what was being said until the very last word falls into place. I want to recall one sentence of that kind now, and you will not know what is being said until the last word falls into place, and you will not hear that word even if you're sitting next to me, so I'll repeat it. That from Henry James, from a story called The Abasement of the Northmores. The narrator, speaking of Lord Northmore, said, he made politics, he made literature, he made land. He made a great many mistakes and a bad manner. He made a gaunt, foolish wife, 2 extravagant sons, and 4 awkward daughters. He made everything as he could make almost anything. Thoroughly pay. Thoroughly pay. Now, what I'm going to offer you today is not quite that curly, but it does unfold. So I'd ask you to stay with me until the last piece falls into place. We meet really in dark times for the defense of religious freedom against the government of the day. And we meet virtually on the eve of the arguments in the Supreme Court in the Hobby Lobby case on religious freedom, set against the mandates in Obamacare. The briefs have been cascading in. Let me say something very quickly here in order to put certain things aside quickly on this matter of a corporation or a business with a religious character. A corporation is an association of free persons, and no one is contesting any longer that a corporation, for many legal purposes, has the standing of a person. Now, as Aristotle taught us, every association is aimed at some notion of a good, whether it's the good of making shoes for profit or the good of relieving famine. It should be clear both from the legal precedents and from the logic of the thing that there is no plausible way of saying that among all of those things that may shape the notion of the good sought by a corporation, a religious understanding is the only one that must be ruled out. as illegitimate. I don't see any tenable way of saying that. On these points, I'm fairly confident that my own side will prevail in these cases. But we could prevail on these points and still lose the case. The real sticking point, the heart of the matter, I think, will come, I'm convinced, to the problem I'm dealing with today. Even people experienced in politics were rather jolted to discover the Obama administration had deliberately chosen as a political stroke to pick a fight with the Catholic Church by compelling Catholic institutions and Catholic businessmen to cover abortifacients and contraceptives in their medical insurance. And what could be said here, of course, for the Catholics will be said just as well for the Mormons and the evangelicals. The religious, now embattled in the courts, are persistently invoking the First Amendment, that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And yet it seems to be coming as a surprise to the religious and their lawyers so late in the seasons of our experience as to how thin and equivocal the First Amendment would be as a support for their religious freedom. We can deliver some sobering news quickly here, I think, by recalling that case that has slipped into the fog of memory, the case of Father Permely back in New Orleans in the 1840s, where Father Permely was prosecuted for violating a city ordinance that forbade funerals with open caskets, apart from a certain selected mortuary. The law was passed supposedly as a health measure. Father Permely was prosecuted, he was fined. The case was carried all the way to the Supreme Court as he invoked his rights of free exercise under the First Amendment, and of course the court just rejected the case in a stroke. We have no jurisdiction because, as most people understood at the time, those first 8 amendments, since called the Bill of Rights, have no application to the states. They are restraints solely on the federal government. As many people know, it was not until, in this room now, Paul, it wasn't until 1925 that the provision on speech in the First Amendment would be applied by the Supreme Court to the states. This is the saying went, that these certain rights, parts of the Bill of Rights, would be incorporated against the states through the 14th Amendment, the Due Process Clause. It wasn't until 1940, in the Cantwell versus Connecticut, that the court would apply to the states the provision on the free exercise of religion. Up to that time, we may ask, what is it that protected religious freedom in this country, other than the people themselves, who made manifest in different ways that they took that freedom seriously? Yet only 7 years after Cantwell, in the Everson case, Justice Hugo Black took the First Amendment as his lever for inverting the Establishment Clause. So instead of a clause barring the federal government from interfering with religion in the separate states, the clause would be converted by Black and his colleagues into a clause that would work toward driving religion and the religious out of the public square altogether. Indeed, it's one of the unnoticed ironies in the history of our law that it was the political process that worked to disestablish religion in the states long before Justice Black. And in recent years, that political process has worked to the minor rescue of religious freedom, as many judges and politicians have been content to purge religion from the public square. But since the time that the court lifted the provisions on religion to the level of clauses enforced against the state, the trend produced by the liberal mind has been one of reducing religion to a body of beliefs with no claim to truth, and no claim to be taken seriously then by anyone who does not share those beliefs. It may be no surprise then that we find no ready refuge now in invoking the First Amendment in defending religious freedom. It seems to come as a surprise, I've found, to lawyers and even many judges to learn that there was a serious argument at the beginning about the Bill of Rights, and the concern did not come from people who reserved about rights, but who thought that the Bill of Rights would have a rather truncating, narrowing effect on our rights, as seen through expressions like that we think that we have those rights only because they're posited, set down in the positive law of the Constitution. You see this reflected in people who say, those rights I have through the First Amendment, as though in the absence of that amendment, you wouldn't have the freedom to speak, to assemble, to exercise your religious freedom. Now, ordinary folks may invoke their rights under the First Amendment without quite realizing that they're appealing mainly to the positive law of the Constitution. But clearly, their understanding runs deeper. In their natural understanding, I think, they do seem to think that they're appealing to something in principle right, something closer then to a natural right, which would be there even without the Constitution. Now, in that notable letter that Matt mentioned by George Washington, so characteristically terse, and yet with it all magnificent, Washington remarked to that Hebrew congregation in Newport that it is now no more that toleration is spoken of, as if it were the indulgence of one class of people that another enjoyed the exercise of their inherent natural rights. And several years earlier, Madison, in the Remonstrance against religious assessments, used similar language to talk about religious freedom as one of those unalienable rights. Now, of course, that natural right to be left undisturbed in religious life did not necessarily entail the fuller set of civil rights that attach to citizens, and certainly it didn't entail political rights, for Jews could not hold office or even vote in Rhode Island at the time that Washington wrote that letter to the congregation in Newport. It also went without saying that the natural right to practice one's religion would be governed and restrained by the laws that were rightly binding on everyone else because they sprang from the same ground of natural law and moral reasoning that entailed the freedom of religion. And so the laws that barred homicide would bar the burning of wives on funeral pyres, of husbands, even if the act were done in accord with a religious code. And yet the complications run deeper than that. If we take seriously the claims of freedom of religion as a natural right, we discover with a sobering jolt that the conventional and familiar arguments for religious freedom suffer a critical embarrassment, for those arguments are not offered in the currency of natural rights, with reasons that are accessible to even to people who do not share the convictions of the religious. The defenders of religious freedom offer foremost an avowal of their beliefs sincerely held. But in that way, the advocates of religion find themselves backing precisely into that libel of religion that John Courtney Murray warned about years ago. They're willing to identify religion with a set of beliefs, that is to say, imperfect knowledge, with no claim to truth or validity for anyone who does not profess to share those beliefs. On the other hand, if we take seriously the properties of religious freedom as a natural right, we are led to the recognition that the defenders of religious freedom these days may find quite as jolting, or at least uncongenial, for we would be led to the recognition that not everything that calls itself religion has a claim to be taken seriously with the same respect or invested with the same cluster of rights to their practice. The pieces begin to sort themselves out as soon as we remind ourselves of the logic that attaches to natural law and natural rights. Aquinas observed that the divine law we know through revelation, but the natural law we know through that reasoning that is accessible to human beings as human beings, we might say natural to human beings. As my friends know, in my own experience as a teacher, I found that the one example of that kind of reasoning that is understood at once is that fragment written by Lincoln as he imagined himself to be engaged in a conversation with an owner of slaves, asking, why are you justified to make a slave of the black man? Is it because he is less intelligent than you? Then beware, the next white man who comes along, more intelligent than you, may rightly enslave you. Is it because he's darker than you? Beware again, the next white man who comes along, with a complexion even lighter than yours, may rightly enslave you. The upshot is that there's nothing you could cite to disqualify black people as rights-bearing beings that would not apply to many people other than blacks. At no point is there an appeal to revelation or faith. It's simply principled reasoning. It is accessible to people across the religious division, the Catholics, Baptists, atheists, backgammon players, across the. Some of us have simply then used the same argument when it came to the pro-life movement. We asked, why is that offspring in the womb anything less than human? Doesn't speak yet, neither do deaf mutes. doesn't have arms or legs. Other people lose arms or legs in the course of their lives without losing anything necessary to their standing as human beings to receive the protections of the law. Once again, there is no appeal to revelation of faith. You don't have to be Catholic to understand this argument. In fact, that is exactly the argument of the church. You don't have to be Catholic. It's a combination of embryology, the facts of science, woven with principled reasoning, right? And so I think once that is in place, it was quite telling in this respect when Bishop William Lowry spoke to the Conference of Catholic Bishops a couple of years ago in resisting those controversial mandates under Obamacare on contraception and abortion. Bishop Lowry made it clear that Catholics were not seeking an exemption from the mandates on abortion on the basis of their beliefs. They were pronouncing those mandates to constitute an unjust law, no law at all, and therefore rightly binding on no one. This was not, he said, a Catholic or a Protestant position, but an American position. Now, Bishop Lowry cast the argument for religious freedom around the claims of conscience, but he made it clear that he was not using conscience as it's been used and virtually unraveled over the years in the claims of conscientious objection, where it's been taken to mean any conviction that a person holds with earnest passion. The bishop was appealing rather to conscience in the sense that was once explained with exquisite care by John Paul II, where he said conscience as an understanding ordered to a body of objective moral truths. He remarked on the facile tendency to accord to the individual conscience the status of a supreme tribunal of moral judgment. But in this way, he said, the inescapable claims of truth disappear, yielding in their place to a criterion of sincerity, authenticity, being at peace with oneself. So much so that some have come to adopt a radically subjectivist conception of moral judgment. But with a corrupted or relativized version of conscience in religion, religious moral teachings can be reduced to simply beliefs in the modern, vulgar sense, and hence the line grown familiar among certain political figures like Ted Kennedy, Mario Cuomo, John Kerry, Joe Biden, to name some of the intellectual heavyweights here, that they would not impose their Catholic beliefs on anyone else. And as a joke around, they wouldn't impose them even on themselves. But when we're clear that the case for religious freedom is cast now as an argument in natural law, moving beyond beliefs and appealing to objective moral norms, accessible to our reason, the problem of Obamacare and the mandates becomes transformed. And by transformed, I mean a shift that suddenly alters, for lawyers and judges, the landscape before them and leaves them uncertain about the terms that would guide them. For consider this problem of two owners of businesses. Both of them object on moral grounds to the mandates of Obamacare on abortion and contraception. One is a Catholic whose understanding has been informed by Catholic teaching on these matters. The other man claims no religious attachment. He's formed a moral objection to abortion, say, solely on the grounds of that principled reasoning that the church itself teaches in natural law. Would we actually say that the Catholic businessman then had a stronger claim to challenge the laws on grounds of religious freedom, when his reasoning, it was in no way different from that of the businessman, who reached his moral conclusion with the same weave of empirical evidence and principled reasoning that forms the teaching of the church? Are the claims distinguishable on any grounds that matter? And does one position claim a certain dignity as a claim to religious conviction or religious freedom that is not available to the man who is standing against the law, but using the same moral reasoning used by the church? We might ask then, with the label stripped away, is one man being deprived of his religious freedom and the other deprived of nothing of comparable moral or constitutional standing? The confusion over beliefs and reasoning was on display in a notable victory we had in the courts this past summer, when a federal appellate court in Colorado went to the aid, for a moment at least, of the Green family, the owners of Hobby Lobby, the craft stores, and the chain of Christian bookstores. An opinion was written by a good friend of mine, Tim Timkovich, used to be the Solicitor General in Colorado. The Greens offer a program of health insurance to their employees, and under Obamacare, they'd have been obliged to cover in their plans contraceptives and abortifacients. The Greens assert among their beliefs a belief that human life begins when a sperm fertilizes an egg. A belief? That word would surely come as news to the authors of all the textbooks in embryology and obstetric gynecology who report that point as one of their anchoring truths. The Greens also believe that they would be facilitating harms toward human beings if they helped to provide drugs that prevent implantation in the uterine wall. Well, since the blocking of implantation does kill the nascent life, we may ask, what is the part that belongs here to belief rather than truth? Our friends litigating religious freedom feel pressed to argue within the grooves of sincere beliefs because they're the terms that the courts have confirmed and the judges seem to recognize. But in this way, they plug into a virtual trend of cases that has seen conscience reduced or relativized to virtually anything that a person sincerely believes, and religion itself relativized until it is detached from any notion of God and the law springing from that God. Well into the 19th century, the judges could invoke, like Stephen J. Field at the end of the century, could invoke Madison's understanding of what is religion? The duty we owe to our Creator and the manner of discharging it. But as the judges dealt with claims of conscientious objection, the conscience they were protecting did not require the commands of a lawgiver, the presence of God, nor did it require an elaborate body of theology, because, after all, a late revelation could be as valid as an earlier revelation that hasn't been worked yet into a system of theology. Religion did not require a body of moral teachings with a claim to truth. In fact, the religious sense could be supplied simply by passions that were thought to offer the functional equivalent of religious conviction. You know, Paul, remember, was the Walsh case, where he said, have no religious convictions at all, you know, just believe in a force in the universe, and yeah, we'll cover that one too, right? And Justice Brown said, well, it does a lobotomy on the statute, but what else can we do? And so we try to vindicate a ministerial exception to the laws on employment, and we insist that churches must be free to determine who counts as a minister according to their own criteria and teaching. But does that freedom from intrusion by the government apply as well to the ministers appointed under the Church of the Flying Spaghetti Monster? Or even worse, does it apply to Satanists claiming the standing of a religion? We can't detach ourselves from judging Satanism or radical evil. And in the same measure, we cannot detach ourselves from the task of discriminating between religions that are more or less plausible, more or less legitimate, based, I'm afraid, on the substance of what they teach. No argument that seeks to explain a just regime of religious freedom and a sweeping protection for anything that calls itself, no argument of that kind could possibly offer a coherent moral account when it insists, as part of its argument, on a posture of indifference to radical evil. The canons of reason will ever be woven into the laws on religion, even in judging what is plausible or implausible and what is reported to us about the Word of God. And as Michael Novak has pointed out so powerfully, those canons of reason have been bound up from the beginning with the American law, with the Creator who endowed us with rights. That was the Creator mentioned in the Declaration of Independence, the author of those laws of nature, including the moral laws. That was the God of the Logos, of reason, who is understood to have brought forth as the peak of his creation those creatures with the capacity to give and understand reasons over matters of right and wrong. In the beginning was the Word, was Logos, was reason. The same God who revealed himself to us also gave us the gift of reason, and reason would have the office of drawing out the implications of revelation. There is no understanding of religion more bound up with the deep principles of the American regime and the very ground of our laws. Now, that's not to say that we would be retreating to some notion of the God of the place, the God associated with this tribe of Americans. The God of the Declaration was not a local God. You know, the Ten Commandments were not municipal regulations for the immediate vicinity of Mount Sinai. Serious Protestants, Catholics, Jews understood the God of creation as a God with a universal jurisdiction, the author of moral commands universal in their reach. Not only was that God and his laws comprehensible, but there was also accessible to us through reason the case for the existence of God, whether it was put forth as a first cause, the uncaused cause of all things contingent, or whether it was put forth in the style of an argument based on probabilities in the style of Richard Swinburne at Oxford. We can put that one decorously to the side, though, because we're not likely to hear that sounded in the courts. But we could return to that matter now, to the very ground of the polis and the law. As people at Hillsdale know, Aristotle taught that the mark of the polis, the polity, was the presence of law, and law sprang directly, distinctly from the nature of that creature who can give and understand reasons over matters of right and wrong. Aristotle expressed in that way the classic understanding of the connection between the logic of morals and the logic of law. And what I put before you today is that the freedom of religion may find its firmer ground by insisting again on that connection between reasoning and law, between the reasons that support our religious convictions and the religious freedom we would seek to protect through the law. The beginning of the argument would be to remind people of what that connection was between the logic of morals and the logic of law, which seems to be so widely forgotten by lawyers these days. In the strict sense, a moral judgment moves beyond statements of personal feelings, private taste, private preference, and it speaks to the things that are more generally or universally right or wrong, just or unjust, for others as well as ourselves. And in the corresponding way, the law moves by overriding claims of personal preference, private belief, subjective belief. It imposes a rule of justice that claims to hold for everyone who comes within the reach of the law, so that in the classic understanding, we do a portentous thing when we impose laws on other people. And that move will always call for a justification, an explanation of what makes it just or rightful for others as well as ourselves. It makes it just to impose this law on someone with different preferences. It used to be understood that those characters we call moral agents have the capacity to reason about the grounds of their well-being. They have a presumptive claim to all dimensions of their freedom, and the burden lies with the law in supplying a moral justification for overriding that freedom. When we view the law through that kind of a lens, the burdens of justification for the law would be altered now and deepened. And so before the law would impose the mandates of Obamacare on the owners of Hobby Lobby, the law should bear the burden of showing that there's something deeply unreasonable about the understanding held by the Greens, that lives destroyed in abortions cannot be anything other than human lives, that those lives are inescapably innocent in the sense that they cannot be the source of intentional wrongdoing, that the standing of those offspring as human beings cannot be in any way contingent upon their height or weight, or whether they are speaking yet in sentences. And unless there is a new right to kill for one's own private interest, the justifications that must be offered for the taking of those lives must be on the same plane as the justifications we demand for the taking of any other human life. Now, unless the government can have something plausible to say on these points, it should back away from any presumptuous willingness to displace the moral code of this family with policies that cannot supply more than some rough theories of utility or some vague notion of a public good. This is indeed the question that the court would be compelled to face if it would take seriously the reasoned ground of the position offered by the Greens, if that is what is offered to the court instead of beliefs. And yet if the court did that, it would be compelled to address for the first time the point it was content to evade in Roe versus Wade, the point marked in all the textbooks on embryology and obstetric gynecology on when human life begins. This could be the moment finally to face that question. The moral argument here may be deepened by pointing out the claims that the Greens have foregone. They do not seek to make the kind of argument we have seen in the past on the part of people who object to that portion of their taxes being used to support the United Nations or unwed women on welfare. The Greens understand that they're already committed through the nexus of the tax system to support abortions funded by and promoted by the government. But the question now is just why the Greens should be compelled to support abortions more directly and personally through the medical services they fund for their employees. In another day, the very notion of public authority compelling a private person A to make payments and transfer his property to private person B would have been marked as the plainest example of class legislation, a form of legalized theft. And if done by the federal government, it would have to come clearly under the Fifth Amendment as a taking of property without justification. I didn't have time to work it in, but in the old legal tender cases, Justice Chase said, look, we cannot take property for public use without compensation. You think we get around the whole principle by simply taking it not for public use, but transferring it to some other private person? Now, I began making arguments. I'm sorry, let me just back up. If a service is mandated by the federal government should be required to fund that service, not transfer a public service to private persons to bear at private expense. That convenient device simply managed to avoid the discipline of constitutionalism, for it frees the government from the need to raise the money to cover its own commitments and justify then to the voters the added taxes that it's laying upon them. In the case of abortion, the surgery is readily affordable by most people who desire to have it. And if an additional child is really seen as an economic burden, then it would make even more sense to borrow money for the abortion as to borrow money to pay for a car or a smartphone. When we bring together these points, the case for imposing on private persons the obligation to fund abortions for other persons would not survive the tests of justification we once thought spring into place for any measure that could be imposed on the public with the force of law. The readiest general rationale is that the measure would be necessary for the public's safety or health. But abortion is not a procedure that relieves any illness or cures any disease, for pregnancy is not a state of illness. And if the offspring in the womb cannot be anything other than human, then it could hardly enhance the public safety by withdrawing the protections of the law from 1 million human beings every year. Now, I began making these arguments about a year ago, and Tom Spencer heard me making them in the fall. But just this past November, we had 2 decisions in federal courts supporting the religious plaintiffs and moving precisely within the lines of the argument that I'm sketching out here. In early November, we had our friend Judge Janice Rogers Brown writing for a panel in the D.C. Circuit in the case of Gilardi versus U.S. Department of Health and Human Services. And about 2 weeks later, we had Diane Sykes in the Seventh Circuit writing in the companion cases of Corte versus HHS and Grote versus Sibelius. It was telling, I think, as to what both judges made clear it was not at issue here. As Judge Brown wrote, the case was not about the sincerity of the Gilardi's religious beliefs, nor does it concern the theology behind Catholic precepts on contraception. Judge Sykes was willing to leave uncontested the sincerity of the plaintiffs and move the argument to another level, and both judges moved to that level. A right to contraception was not engaged in because neither the laws nor the owners of these businesses barred the access of anyone to contraceptives. Judge Brown, testing the matter severely, noted that the government has failed to demonstrate how such a right to contraception can extend to the compelled subsidization of a woman's procreative practices. Judge Sykes observed the government had 2 interests at stake. First, the interest in public health, another one in gender equality. But even if these interests would be served by diffusing contraceptives more widely to the land, why would any of this justify a policy of forcing an unwilling person to bear a direct personal responsibility in funding these services for any other particular person? As Judge Sykes pointed out, contraceptives could be distributed to the population at large in many ways. You give people tax incentives either to produce them, to supply them, to consume them, but the government could also buy them and just diffuse them, give them away. But with funds it has to raise from the public by justifying taxes. In other words, the ends of public policy can be accomplished quite readily without compelling any particular person to buy contraceptives for anyone else and compelling him at the same time to violate the moral principles taught by his church. As for that matter of public health, Judge Brown noticed the government had nothing to say that on that point left so conveniently unnoticed these days, except for by the World Health Association, that certain oral contraceptives have been classified as carcinogens, marked by an increased risk for cervical, liver, and breast cancer. Now, both Judges Brown and Sykes insisted that religious beliefs had nothing to do with this case. The matter was treated most aptly by bringing to the case the discipline of testing in a demanding way the justifications that should be required in imposing laws, restricting personal freedom, commandeering personal property. It was a style of judging that was more familiar before the New Deal and the advent of the administrative state. But that mode of judging was available to Judges Brown and Sykes now because while the judgment did not hinge on religion, the cases were being argued under the Religious Freedom Restoration Act, or RFRA, as they call it. That act put upon the government the test of whether its ends could be attained with measures that did not restrict the freedom of people as they were governed by their religious convictions. Can you do this more narrowly? In other words, under the banner of religious freedom, the Congress had simply authorized judges to do what judges had done in the past. It would be enjoined to do, under the premises of a constitutional order, to test in a demanding way the laws that would restrict personal freedom in any domain, including the freedom to run a business. The Congress had carved out a domain in which judges were free to do what they should be doing across the board in all other cases. Now, what I'm arguing here is that the strongest argument on the side of the Green family and the other religious people will be found not in appeals to belief and sincerity, but to the principles that are bound up with a constitutional order. And the deeper point here is that there's nothing in this approach that diminishes the dignity or the standing of the religious life. This is not, in the moral scale of things, a lesser argument. For what people may no longer notice is just how deeply these principles of constitutionalism are woven in with our religious tradition. And the deep truth of the matter is that the religious tradition does not come into our law and our lives as a set of eccentric beliefs, begging for indulgence and exemptions to the laws laid down for others, but rather our religious teaching has formed the deep moral reservoir on which the law has drawn. Our language of law speaks of persons, rights, injuries, but these terms are given a deeper resonance by our religious tradition. For something else comes into play to tell us what is so deeply portentous about the taking of a human life, or why it is hardly trivial to restrict the freedom or take the property of those beings we call moral agents, who alone can impart a moral purpose to property and to inanimate matter. People will tell us of their concern for employment and for those without medical insurance, and we ask, are you concerned about all of those people, including those you don't know? Why do you assume that they're all worthy of your concern? Are you backing into all men are created equal? At the center of everything is that remarkable creature John Paul II described as the human person. And nothing has enlarged our sense of the moral meaning of the human person than the teaching long preserved that that person was made in the image of something higher. What other teaching could have shaped Lincoln's understanding when he remarked that nothing stamped with the divine image and likeness was sent into this world to be trodden upon and imbruted by its fellows. The law has lived and continues to live on the moral capital of our religious teaching, even while the awareness of that connection has fled the memory of most lawyers. In my book, Natural Rights and the Right to Choose, a beautiful book that's used all over Chicago by my family as a coaster to put under drinks. In that book, Natural Rights and Right to Choose, I recall this incident from years back when I'd been commissioned to do a piece on the Holocaust Museum, newly opened in Washington. I took with me my friend Allan Greenberg, the architect. And as I moved through the hall, I suddenly came upon a scene that's been encountered by many people, many visitors, a vast vat filled with shoes. The shoes of the victims that the Nazis thought they could use again or sell. And what came flashing back at that moment were those searing lines of Justice McLean in his dissenting opinion in Dred Scott when he leaned in and said, "You may think that black man is chattel, but he is a creature made in the impress of his maker. He is amenable to the laws of God and man, and he is destined to an endless existence. He has a soul that will not decompose when his material existence comes to an end." I said at the time, you have the full measure of the situation by realizing the Nazis looked on this scene, they thought the shoes were the durables. Now, I have colleagues back at Amherst who will take as their signature tune that line from Nietzsche amplified by Dostoevsky, that God is dead and everything is permitted. They are people with large natures. They are prepared to engage their sympathies for all species of hurt suffered by the mass of mankind, but even they would have to concede that they cannot give the same account of the wrong of slavery and the wrong of genocide that Justice McLean was able to give. They cannot give an account, cannot give the same account that serious Christians and Jews can give, and that is how our religious tradition bears on our laws every day. Now, my argument here is that we've backed ourselves into a rather impoverished and self-defeating mode of argument, as we've been content to settle in with appeals for religious freedom based upon sincere beliefs, as though beliefs sincerely held had a claim to our respect. Anyone will tell you that those zealots who flew their planes into the World Trade Center on September 11th no doubt earnestly believed the doctrines that had taken hold of their lives. And yet our respect is not summoned and commanded by the report that they held to their beliefs with tenacious sincerity. I fear that my friends in the coming cases will cite the sincere beliefs of the Green family and others, and the liberal judges will set their beliefs against a statute that vindicates deep constitutional rights, including those rights to contraception or abortion, or as the government puts it in its brief, statutorily guaranteed benefits of great importance to health and well-being. Set that against beliefs, and beliefs are a loser. My argument may be crystallized then in this way. To the extent that we cast our argument along the lines of belief and sincerity, we can do no more than plead for an exemption from the laws imposed on others. But that kind of an argument distorts the truer moral character of the argument we are making. For we truly see these mandates as wrongful laws, which should be enforced on no one. And so why should we resist repairing to those deeper principles bound up with the very logic of constitutional government? For they cast their protection over all of us, and we are not diminished or demeaned as a religious people by appealing to the principles that protect us all. If we return for a moment to those two owners of businesses I mentioned earlier, one Catholic and the other who objects to abortifacients, but with the same reasoning used by the church. The irony here is that this argument under RFRA will protect the Catholic businessman, but not the other one, holding to the same moral position. Now that pierces, I'm afraid, to what is problematic about RFRA. But the point of consolation may be, if there's a point of consolation, that RFRA has now carved out a domain in which judges may be able to do what they were once able to do in protecting personal freedom, and from there, the understanding may spread back to reclaim that wider terrain it used to command among lawyers and judges. If I'm right in spotting the real tension or the problem of coherence in the argument, that we need, as I've suggested, some serious work in recasting the arguments that the defenders of religious freedom have been making in the courts. The job may be made easier by the fact that this task of recasting simply requires us to restore the things that were once widely known among lawyers, which can never be coherently denied, namely that necessary connection between the logic of morals and the logic of law and the demanding burdens that the law should have to face before it imposed on the religious or the non-religious these mandates on abortion and contraception. As my friend Jade Budashevsky noted, many of these things involve the things we cannot not know, the things we can never help knowing. But then it may be the hardest thing to teach again what we as a people and lawyers have been taught now not to understand. Yet it's not hard to teach the underlying logic anew because that logic has never been purged. Still, if the task of teaching seems daunting, we should remind ourselves that some of us have seen in our own lifetimes Hugo Black recasting the law on establishment of religion and the very meaning of religion beginning in 1947. It was a deeply false teaching, false in its historical construction, false in its meaning of the First Amendment, and yet so deeply did that recasting take hold that justices like David Souter would refer to it as a firmly settled part of our jurisprudence, as though it were woven into the text of the Constitution itself. Justice Scalia set off years ago to teach us about originalism. Clarence Thomas to teach us how to recover the Commerce Clause as it used to be. If we think these things are worth doing, the judges are in a unique position for teaching, and if we are to teach anew, we might as well start now. In our own case, there's no need to contrive anything new. It truly is a matter of teaching anew the things that judges once used to know and could easily know again because those truths have always been there. But to give an account of the reasoning and the truths that form the ground of our religious conviction is to give, I put to you, a more accurate and faithful account of the law we are seeking to describe and a more coherent account of the jurisprudence we would seek to shape. And a jurisprudence that can explain its moral ground is a jurisprudence that does not back away from explaining the justice it means to do. Thanks very much. Thank you. Dennis said I should dance after that.
We have time for a few questions. If you raise your hand, microphone.
Would you identify yourself, too?
John Soliday, independent economist. Professor Arkes, you mentioned that God gives us reason, but there's another issue. I'm thinking he also gives us the Ten Commandments and the Judeo-Christian traditions. And I'm wondering, to me, I mean, it would seem that it's that's the set of three that lead to the universal moral law. And it's not reason alone. The disquiet I have is to avoid the Enlightenment and, rationalism and statism and Rousseau kind of stuff that's accessible through some sort of reason. So there's a disquiet with reason divorced from those moral traditions. What is your view of that?
Did you want me to give you my reasons in response?
Well, I want...
I'm
I'm asking you for the truth.
And it is accessible through what medium? It's like somebody years ago at Georgetown said, "Professor, is there an alternative to reason?" I said, "Did you want to dance?" Look, it is so woven. Remember, it was the God of the Logos, and as Aquinas said, if God wished me to be ruled in everything by faith, He wouldn't have given me the gift of reason. James Wilson said, our James Wilson, the Father Sinner, said, people give us two sources of the law. One, that it emanates from a lawgiver. The second, that it's in accord with the canons of reason. But he was citing Burlamaqui on this, his main, and Burlamaqui said, but our confidence that this emanates from a lawgiver is that it survives the test of reason. It seems reasonable. I used to, with my friend David Novak, I tweeted him, I recall that scene with Abraham negotiating with God over Sodom and Gomorrah. And Abraham says, well, should the God of the Lord of justice not himself be just? What if I find 50 wanting 5, and it goes all the way down? I was asking David, was he telling God that God was not clear in his revelation? Or was he, and David said, well, you've got to be reasonable. Well, he's asking God to be reasonable. So I just have a thesis from a student doing a thesis on C.S. Lewis and natural law, and making the argument with C.S. that they were all combined. If Moses came down from Sinai and said, look, he said, don't worry about lying down with somebody who's not your wife. Don't worry about that one anymore. And don't worry about taking the thing. You probably say, wait, are you sure you got that one right? We'd probably do a double take and say, are you sure of what God told you, So I'd say, we ask, where did we get this remarkable creature with the capacity to understand, the Greek notion of epistemonikon, universals, not bounded by space? That's a remarkable thing. And some of us think we got that because there was a decision made long ago that there should be something rather than nothing. It is part of a whole scheme. And after all, as Matt, what's taught here is that the whole case for the American regime for natural equality always begins with a sense of the inequalities found in nature, that no man is by nature the ruler of other men, in the way that God is by nature the ruler of men, men are by nature the ruler of dogs and horses. James Wilson would say, supreme power would be justified in the case of he who is supreme. In other words, that understanding of those inequalities, of the presence of that creator who endowed us with rights, that has been part of the whole American scheme. And it becomes very hard to disentangle these things, all right? Now, I don't know if that thing will satisfy you, but I'll have to give you an IOU and coming back to it another. Thank you. Howard Sedgwick, who's trying to resist the schemes of vulgar architecture in this town, correct. And Milt Grenfell on the other side is another great ally in this cause. Okay, Howard.
Lower the level, if I may, for a little bit.
Am I speaking too loud?
No, and that is the political realm. What you just gave was a magnificent presentation. I would also say change the title and it becomes a Supreme Court brief. Is there a possibility that the lead lawyer on the Hobby Lobby case would use your arguments? And secondly, even amongst the friends we have on the court, how many of them would support those arguments?
I think they'd recognize them. I think Scalia would and Alito would. And I'm thinking maybe I should get this out in First Things, because I know Sam and Nino both read First. I make the pitch. But I think our lawyers are probably worried about what's going to bring in Anthony Kennedy. That's it. And he doesn't want to see people coerced. Well, maybe they can get through the day with this. This thing about religion, it presupposes that you know what is a legitimate religion. Well, we've been evading that question for how many years? So we'll evade it. We'll keep trucking along and evading it. Yeah, we can't give a coherent account of what we're doing, but it gets us through the day. So my hunch is that they're trying to see what could appeal to the gastrointestinal tract of Anthony Kennedy, and see and we'll use what will work as good lawyer. But as my friend Dan Robinson says, I'd rather lose with our best argument than win with something that just gives no coherent account of what we're about. And I just had a conversation with one of our friends in the court saying that Anthony Kennedy has said that there are no arguments on the side of those who have reservations about the homosexual life and same-sex marriage. It's all irrational animus. I pointed out to my judicial friend that Sam Alito said there are arguments, but none of the conservative judges has given those arguments, put them on the table, and forced Kennedy and the others to address them. There are many things to be said. And they work under this theory that nothing is said in the Constitution about marriage, therefore there is no theory of marriage in the Constitution, no theory that gives the judges a ground for imposing one. Therefore, all we can do is send this matter back to the states. It's a mechanistic theory. The other side will say, you wouldn't say that about interracial marriage, would you? You wouldn't send that one back to the political arena. One way or another, you're going to have to face that question. And the problem is that so many of our friends look upon moral judgments as simply passionate things. The conservative judges will defend religion as something traditional. It's been around for a long time. It's the old problem, of the Euthyphro, rephrased. Is it good because it's traditional, or have we made it ours traditionally because it is good? And some of our friends who, with their aversion to natural law, are afraid of getting into the substance of the moral argument. But my pitch is there is no way to evade that. It is there. Either you're going to have to face it or not. Right? I'd rather we face it and put it on the table and made the other side make some effort to deal with it. Milt had a question. Can I call Milt or another one? Yeah. Milt Granville. I've already lost somebody here too. Some end of the day. Okay. But
it seems to me that in your assessment of the legal profession today, how this kind of thinking is rather absent in it by and large. My observation, my brushes with the legal profession, is that they're taught to win games. There's a gamesmanship they're taught. Winning is everything. They're not searching for the truth. They're not seeking justice. They're seeking to win for their client. Is that a fair assessment? And if so, can that be reformed in law schools?
well, you remind me of Jim Gordon. Tom Griffith sent me this talk by Jim Gordon, the former dean at the law school at BYU, who said, "It is regrettably true that there are many lawyers are corrupt, venal buckets of slime." It's true. He said, but on the other hand, it could be harsh to judge a whole profession by 500,000 or 600,000 bad apples. Look, yes, you do have it right, but one part of the things we're doing with the James Wilson Institute, that we've done, math is done through Claremont, we've done for years, is try to recall to people the furnishings of mind of those people who made the Constitution, who strainlessly and elegantly would make the connection back to those anchoring premises. Marshall, that throwaway line at Gibbons versus Ogden, he apologizes to his readers for spending so much time demonstrating what should stand in the class of an axiom. He assumed that all of his literate readers knew that before I could do a demonstration, I had to understand things like the law of contradiction. A is not non-A, for controlled experiment. If they didn't understand the law of contradiction, there's no way they could understand the experiment. And it couldn't be demonstrated in the course of an experiment. And then Hamilton, in that elegant opening to the Federalist 31 on taxation, forgive me, man, I'll take one. It's about taxation. In the course of that opinion, that argument, he reached no conclusion different from what Bob Dole would have reached. But anyone looking at the text would see at work some different furnishings of mind, because Hamilton put it this way. He said, in disquisitions of every kind, there are certain primary truths, or first principles, upon which all subsequent reasonings must depend. These contain an internal evidence, which, antecedent to all reflection or combination, command the assent of the mind. And of this nature are those maxims of geometry, the two lines cannot enclose a space, two things equal to a third are equal to one another, and of like nature are those maxims of ethics and politics. There cannot be an effect without a cause, that the means must be proportioned to the end, and there ought be no limitation placed on a power destined to effect a purpose which is itself incapable of limitation. Just the way Bob Dole would have said it, I think, if he bent his mind to it. So part of what we're doing is to remind people There was a time when judges, people would not say with Justice Holmes in The Voice of Modernity that the object is to purge all words of moral significance from the law altogether. There was a time before that. And so what we're trying, the best thing to do is you show the students the furnishings of mind of lawyers and judges who once were able to do it, and if we could do it then, what's stopping us from doing it again? Ladies and gentlemen, thanks very much for being with me.
Thank you very much, Professor, for wonderful talk that I think answers some questions we've been all edging around for some time. I look forward to your further thinking on this question, which is very important to us in particular. There is some information when you leave about the James Wilson Institute. I believe there's also a sign-up. Gary, is that correct? So if you'd like to receive their emails and hear more from the professor and see some of his writings, and also information about the fellowship that was mentioned earlier, if you're interested in that, in Naples. Yeah, Garrett's back there. He'll be outside in the lobby as well.
Garrett was a dear former student of mine whose late dad was also a student. So it continues the tradition. Yeah. Thanks, man.
And on your chair, I just bring to your attention a talk we're having here on March 4th, slightly changing our topic, to America's strategic vulnerability, and stemming from the example of the attack on the electric substation in San Jose, California, which you may or may not be familiar with, that nearly caused the shutdown of much of the West Coast. So we're having a discussion on the strategic implications of that and other matters on March 4th. I welcome you to that. But with that, I thank you for joining us today. Please join me again in thanking Professor Arkes.